Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Well,
I'm ready to go on Mr. Fails if you like, or Mr. Graves.
Yeah, no, let's do Mr. Graves, and then they can go take him back and get Mr. Hardy, and we'll do Mr. Fails next so we can get security dismissed. All right, we're going to go on the record in, it looks like 2 cases of Mr. Graves, Jason Tillmage Graves. We've got 24 CR 134 and 24 CR 224. 134 is possession of drugs, methamphetamine, and then paraphernalia and interference. And 224 is a felony theft, and then misdemeanor domestic battery and driving while suspended. The state appears by and through Mr. Sweeney. Mr. Graves is currently in custody. Although it looks like he may have posted bond on one, but then maybe not the other. I'm not sure.
I believe so, Judge. I think he had posted bond on 24 CR 134.
Yes.
And then he was bonded on, he has a bond on the new case, I believe still. Is that right, Mr. Graves?
Yes.
I believe that's correct.
The new case.
24 CR 224 is the newer one.
It got set at 50,000. So
yeah.
All right. On 134, what is your announcement?
So, Judge, we actually do have a global plea agreement on both of these cases. Mr. Graves has been advised of his right in both cases. We've discussed them, spoken to Ms. Norris, reviewed his criminal history. Mr. Graves will be waiving his right to prelim in both cases. On 24 CR 134, he'll be entering a plea of guilty to count 5, which is possession of controlled substance. I think in this case it's methamphetamine. State will dismiss remaining counts. And then we also are ready to proceed on the other case when the court's ready.
Oh, wow. No, you've like totally lost me.
Oh, sorry.
So what 24 CR 134 has a possession of meth in count 1. In count 3, it's an interference with law enforcement. And then count 2 is a misdemeanor paraphernalia. So what is he going to plead to on that?
So he's going to be pleading guilty to count 1, possession of methamphetamine.
Okay.
Specifically for the meth that was in the pipe that was found, which is the substance of the paraphernalia, but that fell out of his pocket. He'll admit that was methamphetamine.
Okay. We probably don't have a report, or do we yet?
No, we don't have a KBI back to my knowledge.
Okay. Mr. Graves, I don't generally like to take pleas on powdered drug charges until we have a KBI report to make sure what we have, and it matches what you plead to or you're found guilty of. However, I can, as long as you understand that there is no lab report yet, and if it came back as something else, you wouldn't be convicted unless you had a positive or an appropriate KBI lab report. But if you want to avoid the $400 lab fee and you want to go ahead and enter a plea prior to receiving that, we'll just cancel the testing of it.
Okay.
And I will accept your plea.
Yes, ma'am.
If you desire.
Yes, ma'am.
Okay.
And Your Honor, just before we get too far down the road, I just want to make sure that everybody's on the same page. Joe, the notes I have from Ms. Norris indicate count 1 on 224 and then count 1 on 134.
That's right. Yep. Judge is just working with 134 right now. So for 134, it's plea to the count 1.
All right.
Okay. And then he's going to plead to a felony theft in 224.
That's correct. And I apologize. I said the meth pipe that was in his possession. I meant the one on the nightstand that was next to his razors, not the one that was on his person. So it doesn't really matter, but that's where the meth was.
Okay. So this one is alleged to have occurred on 5/7/24. This one's alleged to have occurred on March 24th. So he would have been on bond in 24 CR 134 at the time. Excuse me, at the time of 224. All right. So let's start with 134. If I accept your plea, it is on the drug grid. A level 5 drug charge carries a potential sentence of 10 months up to 42 months with the Department of Corrections and up to a $100,000 fine. As long as you don't have 2-person felonies or more, you may qualify for Senate bill treatment, and that is mandatory probation.
Okay.
And until you're evaluated and your criminal history's done, I can't say for sure where you're going to fall. But if you did have 2-person felonies as an adult or as a juvenile, in-state or out of state, and technically if you have 6-person misdemeanors, they're equivalent to 2-person felonies, you would be presumptive prison. Now, I don't know for sure what I'm going to do, but I have to tell you the worst case scenario. So let's say you do have 2-person felonies and the mid-range box is 34 months and I give you 34 months with the Department of Corrections. Then I have the discretion to run the felony theft either concurrent or consecutive since you weren't on probation or parole. Anything you're on felony probation or parole for is mandatory consecutive sentencing. Anything that's a bond situation is discretionary with the court. So if you, and since they're separate cases, your criminal history applies in each case.
Mm-hmm.
So a level 9 non-person felony has a sentencing range of 5 months up to 17 months with the Department of Corrections, up to a $100,000 fine and potential restitution. So if you received 34 and 14, which is the mid-range in the B box, and it was ran consecutive, your controlling term in prison would be 48 months with the Department of Corrections. If they are run concurrent and the time is not added on to one another, but rather runs simultaneously, then 34 months would be your controlling sentence. Again, if you have anything less than 2-person felonies or 6-person misdemeanors, you may very well be presumptive probation.
Okay.
Okay, any questions? There are no mandatory minimum provisions. So I just gave you the maximum sentences. Do you have any questions about how a sentence is computed based on your criminal history and the degree or level of offense?
I just wonder what I'm going to get. That's all. Hope I can lower that.
Okay, well, honestly, it's pretty much a grid. There's a drug and an off drug. Whatever level you're at, wherever your criminal history intersects, that tells me how much time to assess and whether or not you get probation or not.
I'm going to be on probation, correct? Yeah.
I don't know. I don't know what your criminal history is.
Okay. Yes, ma'am.
Okay.
Okay. So, Judge, I've advised him of the total grid and where he falls, but Ms. Norris and I both believe that these will be his first felonies and he'll cross score on them and likely be G box on each, but we're not 100% sure, but that's what we think, where we think he'll be.
Okay. Well, then he would probably end up with probation. If you're granted probation, I can give you up to 60 days in the county jail as a condition of any felony probation. If you've already been in custody, I probably won't, but I can. That's the maximum I can give you in the county jail and award you probation. You will be assessed through a tool that's used by the state for risk assessment purposes to see if you're a high-risk offender or probationer, but they also do a drug and alcohol evaluation. And if you score high on that, then as I indicated, the state has a drug program that you have to complete, but it also guarantees that you will get probation. So you want to be honest in that evaluation process to ensure that you are granted probation.
Yes, ma'am.
Sometimes there are special rules. It doesn't sound like it's going to apply to you, but third time property offenses like burglary, felony theft and felony burglaries, or simple possession drug charges like methamphetamine or cocaine or something like that, they become habitual offenses by the time you hit 3. And those then become presumptive prison. But it doesn't sound like any of those special rules are going to apply to you. But we will definitely know that by the time of sentencing, which generally takes about 6 to 8 weeks. All right, in order for me to accept your plea, I have to know that you've been explained how a trial works and what your trial rights are, and that you understand the rights that you're giving up. So if you went to trial, there may be 2 separate trials for these 2 different cases, unless there's a reason to join them together. But on either or case or together, the process is the same. There are about 30 or 40 people that are brought in on a summons from the community based on having a residence in Butler County and being over 18. Each one of the attorneys gets to question the jurors to make sure that they're getting fair jurors. And I would also engage in that process to ensure that folks understand that You can only be convicted on the evidence that's presented in the courtroom during the trial, subject to cross-examination by your attorney, that you have no duty to present any evidence whatsoever, and you cannot be compelled to testify. And the fact that you do neither of those things cannot be any reason for them to consider you guilty. This burden is on the state to prove you guilty beyond a reasonable doubt, and that burden never shifts to you. Additionally, they must convince 12 jurors unanimously. In other words, they all have to agree that the state met its burden, proved you guilty beyond a reasonable doubt before they could return a guilty verdict. Then you have a right to appeal the conviction to make sure that none of your constitutional or legal rights were violated, and that you received a fair trial, and that there was sufficient evidence to support the jury's verdict. But obviously, if you don't go to trial to begin with, you can't take a direct appeal. If you enter a plea of guilty or no contest, I'm basically going to find you guilty based on your desire to enter a plea in your statements to me today. Do you have any questions about your trial rights?
No, ma'am.
Do you wish to waive your right to trial and preliminary hearing, which is just a probable cause hearing by a judge to ensure that there's enough evidence for the case to go to a jury? Do you wish to waive those rights today?
No. Yeah,
Okay.
go ahead.
Yeah, you can't, you have to waive those rights to take the plea. You
Yeah,
can't.
I want to take the plea. Yeah.
Okay. All right. Very good. Now I need to make sure that you're of sound mind and good judgment. And you're not under any duress. Is anyone forcing you or compelling you to do this today?
No, ma'am.
Anyone threatening to harm you or someone you care about if
No.
you go to trial? All right. Anyone trying to give you money or goods or services in exchange for your waiver of trial and entry of a plea?
No, ma'am.
Have you suffered any recent traumatic brain injury?
Mm-mm. No, ma'am.
Are you presently under the influence of drugs or alcohol?
No, ma'am.
Do you suffer any mental illness that I should be aware of, or any mental disability?
Mm-mm. No, ma'am.
Okay. Are you taking any prescription medications?
None whatsoever.
Okay. Have you been able to effectively communicate with your attorney?
Just now, yeah.
Okay. If you had questions, did he answer them?
Yes.
If you need any additional time with him, I'm happy to give it to you if you need it.
I'm good.
All right. On the sole count in 24 CR 134 of possession of methamphetamine, how do you plead?
Guilty.
Tell me what you did on March 24th of this year, 2024, that caused you to be charged with this drug charge.
I was in somebody else's home, but I'm just taking the charges for it anyway. I called the law myself when I was inside Marianne's house. It was already there.
Specifically, this is just about the possession of that pipe that was on the counter that was yours.
That pipe wasn't usable. It was just a piece of one. But that's fine. I'll take the charges for it anyways, I guess. It was just a piece of one.
Okay, well, again, they can charge possession on a residue amount, even on a pipe or in a pipe, whatever the substance may be. So if that pipe goes to, any portion of it goes to KVI and it comes back positive
It would.
for meth, then it is the basis for a jury to find you guilty of possessing meth.
It was meth. Yes, ma'am.
Okay. And then on May the 7th, which wasn't too long ago, of 2024, did you take a white Pontiac without permission from Pamela and Cynthia Todd?
It's from Mary Ann, the sister.
Okay.
But we was both in it. She just jumped out of the car.
Okay. So it sounds like to some degree you were aiding and abetting each other.
Yeah, she was driving. She just jumped out, and so I got in the driver's seat to move the car, and she was calling the law at the same time because we was in a fight. We was arguing. Yes, ma'am.
Okay.
That never happened. No, ma'am.
All right. Well, did she or you have permission to have this vehicle?
She does. It's her car,
Well, that's
and
not what
I
that-
live with her.
that's not what this charge says.
I know it's it's Cindy Todd's car, but it's Mary Ann's car. Yeah, it's in Mary Ann's possession.
Okay.
At her home, yes.
So I think the thing is that Mr. Graves never had permission from the owner to have the car. And I think that's what he's admitting to, that he never had permission to take that car and that he did indeed drive off in it.
Okay. Is that what you're admitting to, sir?
Yes, ma'am. I was coming back, but I didn't know she was calling the law, and either I didn't need that to happen. But I got pulled over in the meantime of making the circle. Yes, ma'am. I'm guilty.
Okay. All right. I'm going to find you guilty of possession of methamphetamine and theft. I'm going to order a PSI and I'm going to schedule your case for sentencing. On July the 9th. Or you're gone then, aren't you?
Yes, unfortunately, I'm gone that whole week.
You have Mr. Sheets, Friday the 28th, June 28th at 1. Do you want to do him as well on Friday, June 28th at 2 p.m.?
Yeah, that's fine with me.
Okay. All right, Mr. Graves, make sure that your attorney knows how to get a hold of you.
Okay.
With this drug charge, as I indicated, they're going to have to arrange some testing for you. So we're going to need to know where you're at.
I'm gonna be at Second Chance here in El Dorado.
Okay. We'll make a note of that in our court notes. When you get out, if you haven't heard from court services in Butler County, you need to call them
Okay.
so that they can arrange a time for you to meet with them
Yes, ma'am.
and get your PSI done. Is there anything further to come before the court today?
What about lowering my bond?
Judge, we would like to address the issue of Mr. Graves' bond of $50,000. It's understandable on some level why it was set, given the way these cases picked up back to back, but it is fairly high for a person that has had no prior felonies before today. We would ask the court to consider lowering that to a much lower bond, somewhere in the neighborhood of maybe $1,500 cash or surety. He is homeless. He's going to be trying to live at the Second Chance shelter, so he doesn't have a lot of resources. And so we're asking the court to consider allowing him to make that bond. So.
Please, ma'am.
Well, I don't understand why he's in Allen County. Can you explain that to me?
No, he's not in Allen County. He's in Butler County.
Butler County. Yes, ma'am.
Mr. Page's client was in Allen County.
Okay, that's right. That's right. Okay. So I still don't understand how he got out, made bond, I guess. And I guess he got picked up on this and he got a high bond and he hasn't made it.
Right.
Okay.
That's one you said the other day. Mm-hmm.
Well, I think I'm going to set this at 10,000 cash or surety. So I will reduce it.
And that's the 224 bond, you have?
Yes, he's already made the 5,000 on 134. So I'm gonna reduce 224 to 10. Okay,
Thank you.
all right, you will be getting credit for time served, and like I said, if you make bond, make sure that you don't just disappear and then when sentencing rolls around, we don't have the information we need to sentence you, because your bond then will just be revoked until we can
Okay.
get scheduled for sentencing.
I'll be
So
in second chance is where I'll be right here.
okay, sounds good.
No, so is that an inpatient? Because I guess I would just, that's my concern in this case, is because in the 134 case, he did mention that he was homeless and that he might, it looks like, leave for Arkansas. So I guess I would ask that he just remain local and then maybe touch base with the CSO before
Okay.
he goes to second chance.
Yeah, I'll add in this new case a condition of bond that he not leave the state of Kansas. Okay?
Okay.
All right, thank you. We are adjourned.
Sounds good. Thank
All
you.
right.